We're not talking about those clauses in law protecting authors from publishers. We're talking about protecting user rights from publishers.
At many research institutions, a graduate student or a professor is able to sort of access everything from their computer, but they're accessing databases that have been licensed by their libraries. Instead of buying material, libraries license materials, and when they license the materials, the licenses typically contain restrictions on making copies and restrictions on lending. And so that means that a library can no longer do under this contract regime what it was able to do under the copyright regime. And that's true not only of libraries, but also of consumers. So they think they're buying something when in fact they're just licensing. The contract of adhesion means the terms stick to you even if you've never really agreed to them. Somewhere in your subscription agreement you have promised not to make a copy.
Okay, so this really started in the 70s and 80s with software, and now it's pervasive with all the other kind of content that we access.
So the book publishers realize this is a great business model, and so they have followed in the footsteps of IBM and Microsoft. The basic problem here is that copyright gives users a set of rights, and then the contract really tries to override those rights given to users. And so the question is how do you protect the user rights from being overridden by the contract? The question of whether copyright trumps contract or contract trumps copyright is a very complicated one, and it really depends on the country. And it depends on the exception that you're talking about.
Since 1991, various directives in the EU relating to copyright have contained clauses that specifically require the nullification of license terms that override specific exceptions mandated by the directives.
Europe has been aware of this tension between copyright and contract for over 30 years.
The basic principle is, what was the point of negotiating and adopting these exceptions if the licensor could simply override it with a license term? So far in 4 directives, we have these clauses.
With text and data mining, you need to copy large amounts of material, and that copying might be a copyright infringement. In different countries, there have been different legal theories employed to allow the copying necessary to create a search database. But if there's a contract that prohibits that copying, you might not be able to, again, assemble that large search database because that would violate the contract terms. So you're allowed to do it under copyright law, but you might be prohibited from doing it under contract law. And that's the tension that needs to be resolved.
I have a map of the world, and so the first thing that will leap out at you is that other than Greenland, we don't have any of those clauses here in the Western Hemisphere. Okay, this is very much an Eastern Hemisphere approach, and then even more so, you'll see that it's really a European approach. So how do we see if we can get some of those protections elsewhere, especially here in the Western Hemisphere?
The basic message that comes out of all this is if you do not address this problem of publishers and other distributors using licenses to overreach and override exceptions in copyright, the exceptions that users rely upon and have fought so hard for will become meaningless. And if you do not make sure you prevent the overreach of contracts, the user rights will evaporate.